Bill S-206 is at second reading at the Senate. What Bill S-206 is about repealing Section 43 of the Criminal Code. For those of you who aren't reading the Criminal Code every night, Section 43 protects parents and teachers who use reasonable force as a form of child discipline. Repealing Section 43 would essentially criminalize loving parents who choose to use this form of child discipline. So Bill S-206 has the potential to create problems, as has happened in other countries internationally who have banned the use of spanking as a form of child discipline. We've seen in New Zealand, for example, some scary cases come up where children were taken from their families because the parents used spanking as a form of child discipline, and the law outlawed that, and then subsequently the children were taken away. The parents weren't abusive, and the families were broken up over this unnecessarily. So there is some dangers associated with repealing Section 43, which is what Bill S-206 aims to do. Back in 2004, a case came before the Supreme Court of Canada. That case aimed to challenge our laws. It aimed to repeal Section 43, and at that time the Supreme Court ruled that Section 43 is constitutional. So we have that precedent standing. The Supreme Court did at the same time place parameters around what it means to use reasonable force as a form of child discipline, and parents can and should inform themselves about what that is, as parents can and should inform themselves about every form of child discipline, be it timeouts or the use of reasonable force or anything else. Cardus Family is not suggesting that this is the main form of child discipline or the only form of child discipline, or even that parents should use it. But what we are saying is that parents are the ones who know their children best, and parents can be the decision makers about this sort of intimate family decision. There's long been an effort to ban spanking. It was always brought up in the past by Senator Céline Payette. At this point, it's actually the result of the Truth and Reconciliation Commission. The Truth and Reconciliation Commission put forward a number of different recommendations, but number 6 suggested the repeal of Section 43 and the banning of the use of reasonable force. The realities that occurred in residential schools are apples and oranges. The abuse that occurred in residential schools cannot be compared to child discipline today in 2017. And importantly, I would argue that the abuse that occurred in the residential schools was a direct result of infringing on family life and infringing on parental rights. Aboriginal children were taken against the will of their parents out of the home and placed in these residential schools. And that is an egregious infringement on parental rights. The parents were not there to protect their children in what became an abusive situation. So really, it's an apples and oranges comparison. There isn't any comparison to be made between abuse in residential schools at the turn of the century and child discipline today. What occurred in the residential schools at the turn of the century would be criminal today under Section 43. If the research did show negative outcomes for children, the result of using spanking, certainly then I would be against it. The research does not show that, and it's important for parents to know that as this becomes more public and more discussed in the media. Where the research shows negative outcomes for children, generally one of two flaws have been made in that research. The first is the confusion of correlation and causation. What do I mean by that? The research in those instances fails to distinguish when the negative outcomes appeared. Were the negative outcomes that the children are showing present before the use of reasonable force or spanking, or did they appear afterwards? Without distinguishing between when this happened or the timing of events, that would be a little bit like having an effective chemotherapy regime but then claiming that it caused the cancer. The other mistake that the research makes is failing to distinguish between abuse, which everyone is against, and spanking as a form of child discipline, 1 or 2 swats on the bottom for a child in the appropriate age range. So the research does not show what is being claimed by proponents of Bill S206. Those who are concerned should be informing themselves on the matter as it moves through the Senate. There will be more information in the public square about this, so parents can come to Cardus Family and read that research report and inform themselves on some of what's gone on around the world in jurisdictions where spanking or reasonable force has been criminalized. So I think parents can inform themselves, and that's the number one important thing. It's an important thing to do as this will be coming up in the Senate. Cardus.ca/family.